feel free to take over the presentation.
Okay. Good morning, everyone. Thank you for being here. This is our first presentation to the Carroll County Sheriff's Office. We very much enjoy the opportunity to meet with you. Since we have such a small group, please feel free to enter your questions in the chat as we go along. And we can, Janice, either take them up on when we hit that subject matter or at our planned question breaks. I'm Lisa Kirshner. As Janice mentioned, I've been the public access ombudsman since 2016, and Sarah Clem is the Assistant Attorney General who represents my office, and also an entity called the PIA Compliance Board, which we're going to talk about in due course this morning. The Public Information Act is known as one of our sunshine laws because its underlying purpose is to shed light on government activities and to enable the public to learn about what their government is up to. Some of the topics we're going to cover today have to do with the general structure of the Act, including its general rule of disclosure. We're going to cover some of the terminology in the Act that's important to understanding its specific terms. There's a large portion of the text of this law deals with documents that are exempt from disclosure. This is an all-important topic, I know, for law enforcement agencies because there are a number of exemptions that probably come up quite frequently for you. The Public Information Act provides very precise timeframes in which agencies are required to respond with certain information, so we're going to go over that landscape as well. We'll talk a little bit about fees and fee waivers, and lastly, we'll talk about the kinds of remedies that are available when either a requester or an agency has a difficulty that can't be resolved through discussion, and cover some basic resources that are available to you. The Public Information Act is one of Maryland's statutes. It was enacted by the General Assembly back in the 70s, signed into law by the governor, and it is found in the General Provisions article of the Maryland Code. The general rule that applies to this statute is that, in general, records are disclosable unless there is some specific reason called an exemption that would preclude their release. So right up front at the beginning of the statute, the general rule is stated all persons are entitled to have access to information about the affairs of government, etc., and that unless an unwarranted invasion of the privacy of a person in interest would result, the title shall be construed in favor of allowing inspection of a public record with the least cost and least delay. So that is the all-important ground rule that sets the tone and purpose of the statute. We're going to go over some of the basic definitions in the Act. There are maybe a dozen or so definitions that are found in 4101 of the Act, and then there are more interspersed in various sections. We're going to cover just a few of them today that come up quite a bit. So the first of all, what is a public record? This is an important starting point for the law because the Public Information Act only applies to public records. That's all it applies to. And a public record is any type of documentary material that is made or received by an agency in connection with performing its public business. A public record can exist in any form or format whatsoever. So the format of a document, whether it's digital, whether it's a paper record, whether it's an audio record, whether it's a photograph, whether it's handwritten, makes no difference. The really key critical questions are, is it made or received by the agency in connection with carrying out its official duties? Another key definition is that of a custodian. And the Act actually provides two different definitions of custodians. First, there's the official custodian, which is almost always the person at the top of the agency, for example, the secretary of an agency, or the chief or the CEO, who has legal responsibility for the agency's compliance with the Act. And then there are actual custodians. Those are employees who have actual possession or custody of the record, provided that they're authorized to have it. So very frequently, there will be multiple custodians of the same record within an agency and across agencies, but only one official custodian, for example, per agency. Janice, do you want to take over with our first question?
I'd be glad to. Our first question is, who can ask for a public record under the PIA? So I want you all to take note of all of these categories and sort of make notes to yourself whether you think a prisoner can ask for a record, whether commercial business, what about a resident of another state, someone who does not say who they are, or someone who seems to be submitting PIA requests just for the fun of it. And I'm going to give you a moment to just sort of consider that and note your questions, note your answers. And
so we were doing
the answers.
Yeah, go ahead.
So these are the answers, and Lisa can go into more detail about them.
So if we were doing this in person, we could have had a show of hands, but this is just to give you some examples. You see the answer here are straight yeses. Every person or entity on this list is someone or something that's allowed to make a Public Information Act request. An inmate, a prisoner, yes. A business, yes. Someone who lives out of state, yes. In fact, it can be someone out of the country. Someone who does not reveal their identity, yes. Someone who is just doing this for their private entertainment, yes. All of those people are entitled to make Public Information Act requests under our law. So we're going to pick up and continue with some definitions. You may well be aware of the definition of a person in interest because it comes up under some important law enforcement related exemptions. But in general, a person in interest is the person that the record is about. If the person the record is about is a minor or is someone subject to a legal disability, then that person's parent or guardian can also be a person in interest. That person's lawyer or authorized representative can also be a person in interest. So as we'll discuss later on, persons in interest in general may have greater rights of access to certain types of records than the rest of the world. So in those limited circumstances, knowing who the requester is can actually be important. Okay, what is a PIA request? The Act actually, the language of the statute actually speaks about applications to inspect public records. That's kind of a fancy way of referring to a Public Information Act request. Bottom line is any written request for records is a PIA request. If I scribble a note and drop it off to your office asking for the Sheriff's Department's annual report, that is a Public Information Act request, whether or not I use those words or refer to it as such. Couple points to bear in mind, and sometimes these are not well understood by members of the public who are familiar with the Act, but the Act itself does not apply to information. It does not allow people to interrogate agencies or to ask a series of questions. It really only deals with access to public records. The Act doesn't require you to create records in order to respond to requests. It only deals with records that are in your possession, custody, or control. In the age of e-government, and you've probably already experienced this, many requests are for electronic records or data, and sometimes sorting through these questions with reference to data can be a little bit complicated. So we're going to spend some time talking about that. But first, we have another poll question. Which of the following is a public record? Janice, do you want to take that away?
Sure. So again, there are 5 categories, and you can note to yourself yes, no, or maybe. Do you think an email to your boss about a work project is a public record? How about drafts of work on your home computer, or texts between members of a city council on their personal phones, or in this case, members of the police sheriff's office on their personal phones? An office calendar with your kids' birthdays and doctor's appointments, or third-party vendor files associated with a municipal or county project. Note your answers.
Okay,
And I'm
let's see
going
what
to go
those answers
and
are.
ask.
Oh,
Yeah.
okay. So this is all really a little bit all over the map. Email to your boss about a project you're working on. Yes, that's clearly a public record. It's about your work. You create it in the course of your official duties. Yes. Drafts of a work report on your home computer. Yes. The fact that it's sitting on your home computer rather than, let's say, your office desktop makes no difference. If it is a work report that you're doing as part of your official duties, it is a public record. The fact that it is not a final version of the report doesn't change the fact that that existing draft, as it stands, is a public record created in the course of doing your work. Text between, I'm going to read members of the Carroll County Sheriff's Department on their personal phones. Not clear here. I mean, the fact that the texts are on personal phones doesn't really determine anything. The real missing piece of information here is, what are the texts about? If the text is about somebody's retirement party, no, probably not. However, if they are texts about, carrying out some business of the department, yes, then they are. Note here, by the way, that just because something is a public record does not mean it's going to be disclosable. We have to look deeper to get the answer to that question. But just at the threshold level, are these public records? The text messages between the members of the department, maybe. Office calendar entries with kids' birthdays and doctor's appointments. Not a public record. Doesn't matter that it's sitting on your office calendar. The content is not part of your official, it's not transacting public business. It's part of your private business. Third-party vendors' files associated with a municipal project. Maybe. Here, the fact that they are a third party's vendors' files just isn't determinative. Those files could contain records that are public records, but they might also contain records that are simply part of that company's business operations. So, for example, maybe a company has internal documents that analyze the tax consequences of structuring a contract a certain way. That's probably not going to be a public record. That's part of the company's internal business. On the other hand, communications with, let's say, the municipality about the work that they're doing, its progress, and how it's being carried out, it probably are public records in the sense that they relate to a project being carried out by a government body. Okay, but we're jumping back now to databases. I get a lot of matters in my office that relate to requests for data. Here is kind of the bottom line about electronic data. If you have it as part of your ordinary operations and your ordinary operating capabilities, it's going to be a record within your possession in the relative sense. Now, that doesn't mean that you have to go out and buy new software in order to be able to compile data in the precise way that a requester is asking for, or that you have to reprogram your computers reconfigure your systems in order to come up with the data they want. If the data that they are seeking it or the format in which they're seeking it is not within your ordinary operating capability, then it is not probably not data that you're required to produce under the Act. This type of analysis really has to be done on a case-by-case basis, and it really very much depends on what you have and what your ordinary capacity is vis-a-vis the request that you are looking at. Sufficiency of search. How long, how hard do you have to search for records when you receive a request for them? Well, this is kind of a common sense answer. You have to carry out a reasonably diligent search. And that means you should be prepared to look for the records wherever that you would expect they normally would be kept. It doesn't require you to absolutely exhaust every single possibility for the record, but you do have to make a reasonable and good faith effort to locate any responsive records. If you're dealing with a complicated or lengthy request and one that you suspect may entail some fees, you will want to keep track of key terms that you're using and where you are checking, other personnel you may be checking in with to see if they know where the records are, so that if ever called upon to explain what you did, you'll have that information at your fingertips. Okay. We're going to turn now to the subject of exemptions. This is actually the subject within the statute that takes up the bulk of the law. And exemptions deal with categories of records that either agencies are permitted to withhold, or in some cases that they are compelled to withhold, that they're actually prohibited from releasing. And here we have a little taxonomy of exemptions that apply. Part 1 exemptions are mandatory, and they are sourced in other law. When I say sourced in other law, I mean the prohibition on releasing them comes from a law outside the Public Information Act. Public Information Act will defer to other laws when they govern specific types of records. Part 2 exemptions are mandatory exemptions, meaning you're prohibited from releasing them, and they apply to specific types of record. Part 3 exemptions, again, are mandatory, but they apply to specific information, not necessarily entire records, just information that may be within records. Part 4 exemptions, in some ways, these are the trickiest of them all, are discretionary exemptions, meaning a custodian may be permitted to withhold them. It doesn't mean they always should withhold them. And discretionary exemptions always involve a balancing of interests. So we'll spend some time talking about some common discretionary exemptions. Part 5 exemptions are really very unique, and they come up on a case-by-case basis. These are records that a court may order be withheld. And so they are usually specific to a particular case and a particular issue or question has come up on which a court ruling has been sought. Okay, Part 1 exemptions are the mandatory exemptions sourced in other laws. Some common privileges that come up, some of them are maybe not so common, but everyone's heard of the attorney-client privilege. That's a doctrine originally developed under common law. It has been codified in various rules, and it is indeed recognized by the Public Information Act. The executive privilege, it's a little lesser known privilege, but again, it's sourced in the common law, that is judge-made law, that's made over the course of time. It becomes binding precedent. And is recognized by the Public Information Act. An executive privilege typically is a privilege exercised by the top decision makers within an agency when they are vetting certain types of decisions. Its development originates with the federal government and at the very top, but it can apply to state officials as well. Legislative privilege is a counterpart privilege that applies to legislative bodies. The grand jury privilege is very specific. It applies to grand jury proceedings and materials produced related to grand jury proceedings, such as transcripts. That is another form of mandatory privilege. State statutes, other than the Public Information Act, can provide mandatory exemptions. One I think you're very familiar with probably are the statutes relating, let's say, to the status of juveniles within the juvenile court system. Child abuse laws, child welfare laws, those would be that are codified in various articles of the code, provide protections that apply to minors. Federal statutes.
Lisa, I want to interrupt you for just a moment. This is a good time to address Sergeant Demir's question about juveniles. He specifically asked when an accident, he specifically asked, as the names of juveniles are both either as a driver or passenger, should they be redacted from any responsive documents or accident crash reports?
Okay. Yes, that's an interesting question, and it brings up this is a tricky area where, when you have questions about this area, I'm going to recommend that you check in with your legal counsel, because there are many statutes in Maryland that govern the treatment of juvenile information. But regarding this specific question, there is an Attorney General opinion in Maryland that, in essence, says that not all information about juveniles is protected and privileged. And in particular, information about juveniles when they are a passenger in a vehicle or maybe a witness to an event is not protected. So it is a more limited set of circumstances in which a juvenile's identity or status as a juvenile or involvement in an incident is going to be protected, and generally involves when they are the person in interest, or even more specifically, when the subject matter of the record is such that it would bring or potentially bring the juvenile within the jurisdiction of the juvenile court. So when a juvenile is, say, just a passenger in a car or witnesses something that occurs, that is not an event in and of itself that would be sufficient to bring the juvenile within the jurisdiction of the juvenile court. Hence, it is not privileged under that statute. And I think we have a slide later on which examines the specific section that I'm referring to, that creates a lot of the protections relating to juveniles. So the answer is no. You have a juvenile mentioned in a report about an accident. The juvenile's a passenger or maybe a witness. That's not off limits. So moving on, federal statutes and regs can prohibit disclosure, and as we mentioned, court rules and orders. This is a good place to mention that court records are not subject to the Public Information Act at all. Access to records that are in the possession of the judiciary are governed by court rules. Many of those rules kind of track the substance of the Public Information Act, but they have a different source in law, and they are monitored, administered, and disputes under them are resolved by the judiciary, not by any other branch of government. Okay. States, here's some more, here we go again. The section I was just referring to about juveniles is Courts and Judicial Proceedings, Article 38A27. That is the section that protects information about juveniles when the information is such as would bring the juvenile within the jurisdiction of the juvenile court. And as I'm sure many of you are aware, what are those subjects? Well, they are events or acts, incidents that could lead to a juvenile being declared a child in need of assistance, child in need of supervision, commonly referred to as our delinquency laws, I think those are the two biggest categories.
Lisa, what if the juvenile is the driver?
I'm sorry, say that again?
What if the juvenile is the driver?
if the subject of the report, let us say the subject of the report is that a juvenile is driving a vehicle and is either suspected to be or is determined to be under the influence, let's say, of alcohol or of a CDS. These are crimes. I mean, if committed by an adult, they would be a crime. When committed by a juvenile, they are an act that can bring the juvenile within the jurisdiction of the juvenile court as a child in need of supervision. So in that instance, yes, that is an act that would be protected under 38A27. But again, I think you have to look at the exact content of the record. Suppose the juvenile is a driver, but the child is simply a victim of an accident, maybe the victim of someone else's negligence or someone else's driving under, the other driver was under the influence. That's not an act that's going to bring the child within the jurisdiction of the juvenile court. So I think what you're really looking for is not just a question of, is this child the driver or the passenger, but you have to look at what is the nature of the event or the incident that's being reported and what is the juvenile's connection to it. If it is something that implicates the juvenile either in a crime, something that would be a crime if done by an adult, or something that is suggestive that this child is in need of court supervision or assistance from the court, then it is protected. And then, well, that is kind of summing it up in our last bullet. This protection generally does not apply to police reports where the juvenile is merely listed as a victim or a witness. So an accident report in which the juvenile is not implicated in something that, for example, that would be a crime if committed by an adult. And the cite there is to the Attorney General opinion that I mentioned. And your counsel certainly will have access to that and many other opinions of the Attorney General. These are not binding legal authorities, but they are persuasive to many courts, and courts and lawyers look to them regularly for advice and guidance. Were there any other questions on that specific topic before we move on?
No, thanks.
Okay. Okay. So here are some examples of some other kinds of mandatory exemptions that apply to specific types of records. And the numbers that you see at the end of each line are the reference to the specific sections of the statute that provide for that protection. So personnel records are generally exempt and cannot be disclosed. Traffic citations and charging documents, but only when requested by an attorney. I think this is an instance where the legislature was disapproving the use, the prospecting of business by attorneys, and decided that they would not be allowed to get these type of documents. This can be viewed as an example of one of the few instances where the identity of the requester can actually matter. Arrest warrants and charging documents but only before they are served on the defendant. MVA records with personal information in them. Images recorded by traffic monitoring devices, surveillance images, firearm and handgun records, captured license plates data, and distribution lists. Distribution list is a fairly new addition to the list of mandatory exemptions. And it's intended to protect the type of mailing list that many government agencies will maintain so that they can quickly distribute needed information to constituents or customers of the agency. The purpose behind this exemption is to prevent businesses from using this type of list for the purpose of prospecting business. They didn't want members of the public to be deterred from signing up to get these kind of announcements if they were of use to them, and so they protected the privacy of them. Okay, the personnel records exemption is one that comes up actually quite frequently. Personnel records means just just what you think it would mean. They are records that directly pertain to a person's employment in a government position and their ability to do that job. So this exemption has been construed to cover things such as an application for a government job, performance evaluations or ratings, if you have to supply transcripts or school records in order to get a job, they would fall within the personnel record exemption. Anything relating to hiring, the disciplining, the promotion, the demotion, or the dismissal of an employee are all personnel records. Importantly, internal affairs files relating to police officers or law enforcement officers have been deemed by the Maryland Court of Appeals to be protected personnel records. Now, this is something that every year there are advocates down in Annapolis trying to change that ruling. And I suspect in this coming session, you'll see more activity related to overturning this ruling. But as things stand right now, IAD files are off limits. They are protected personnel records. Just a couple of caveats about this, this exemption. If someone asks for data, let's say data about, let's say, the number of employees, let's say, let me make something up. You know, having a college degree or a certain level of education, or number of employees who have been, employed more than 10 years by the county, or some other type of statistical information. Aggregate data like that generally is outside the reach of this exemption. If it is sufficiently anonymous, meaning the pool is large enough that you cannot trace the data item back to particular individuals. Okay, one exception is the personnel records exemption. Obviously does not prevent the employee himself or herself from getting their own records, and a supervisor of the employee can access that person's personnel file. I was talking a moment ago about the rule that IAD records are protected personnel files. The decision in Maryland that's so held is Maryland State Police versus DeShield, decided in 2015. That is the source of that rule. Distribution list is the exemption I mentioned a few moments ago. You can't, when an agency maintains a distribution list for the purpose of communicating with its constituents, and they have on file therefore lists of names, addresses, emails, telephone numbers, means by which they're communicating with their constituents for some official purpose, then that list and the data in it is off limits, cannot be produced. And the section that says this is 4341. Okay, now we're getting to the Part 3 exemptions, which we're still in the land of mandatory exemptions, but these are exemptions that apply to types of information as opposed to specific types of records. So when you come to some of these exemptions, you may have to look very carefully at whether records can be produced in a redacted form. Medical or psychological information generally cannot be produced. Note that will not apply to an autopsy report of a medical examiner if one exists. Home address and telephone numbers of public employees are off limits, cannot be produced. Trade secrets, confidential commercial and financial information cannot be produced. This, you'll see 4325 right below it applies to financial information of individuals. The trade secret and confidential commercial and financial information in 4335 generally applies to businesses, to entities. And when they apply, that type of information is off limits. Alarm and security system information, I think for obvious reasons, off limits. And now we're coming to a third poll question. What information must you provide about a county employee? Okay, Janice, want to take this one away?
Sure. So again, there are multiple categories here. And just note your answers again. Do you think someone's salary is disclosable? And again, base this on the information Lisa's already given you on what is a public record and some of the mandatory exemptions. What about their benefits selection? Their start date? Can an agency provide the employment contract of its employees? Or their home address? Or the references they used? What about a complaint about performance? And let's give you a moment. And those are the answers. So how did you do? Raise your hand if you got them all right.
Huh.
Anybody? Oh, I should mention
Sarah
that
got them all right.
Sarah. All right.
Sarah always
Lisa, go ahead and explain these answers.
So salary, the salary of a public employee is disclosable. That is, and that's under provisions of the sections we cited, which makes it so. Note that does not apply to benefit selection. Benefit selection really is very often dependent on an individual's family situation, marital status, whether they have kids, you know, where they are in their career, you know, length of time to retirement, all kinds of individual personal considerations come into play relating to benefit selection. And no, that is not disclosable. Start date, yes. Employment contract, yes. I'm thinking of things like employment contract and start date really they have to do with things pertaining to the position itself rather than a specific individual, although start date does relate to an individual. Home address, nope, can't ever get the home address of a public employee. References provided, for example, in applying for a job, no, there's a specific section that makes letters of reference exempt. That's section 403-10. And remember, generally documents created or obtained in the course of applying for a job, obtaining public employment, getting hired are not, I mean, they are protected personnel records, therefore not disclosable. Complaints about performance, nope, that's the epitome of a personnel record that is protected under section 4311. Do we have any questions on topics we've covered so far, Janice?
Yeah, there's an additional question about juveniles, and I would ask Mr. Dixon, maybe you want to weigh in as well from the county attorney's office. You might want to unmute. The question is about if the county sheriff's office policy states that all juvenile information is to be redacted without subpoena, do they then have to give it out if they receive a PIA? Does that override the policy of the county?
So I'll take a stab at this and then turn it over to counsel. An office policy, an agency policy can't override a state statute, generally speaking. It will not take precedence over a state statute. There is, however, and Sarah and I were talking about this before we got on the call today, there is an exemption for sociological data that can come into play, but it will only apply if you have regulations. If you have regulations defining what constitutes sociological data. So that's not a policy that would require going through the adoption of actual regulations. So my answer to my take on this question is no, you can't override the statute by virtue of a policy that your office adopts.
Mr. Dixon, what do you think?
I would agree with that. I mean, I'll see what the background and history of that policy is, where it came from, but I would agree with what Lisa Kirshner just said.
All right, so to summarize,
when you do that, Tim, and if you want to involve our office or Sarah and get her good advice and input, we're available. And if you want examples of what some other agencies have done with the sociological, if you think that might come into play, we can try to hook you up with other agencies that have gone through that process.
I would also just add too, I mean, I think even like local ordinances and sort of the laws that govern counties or localities, they also cannot trump the PIA. There was a case out of Montgomery County that had to do with personnel records where the local ordinance was in conflict with the PIA, and the court found that the PIA would supersede.
Yeah, that's kind of the hierarchy of our laws.
Mm-hmm.
That was the only additional question, Lisa. There are a few more questions about exemptions from Sergeant Demure, including fatal accidents reports. Are those treated differently? Or pictures of injured or deceased? I'm not sure if those fall under the mandatory or discretionary exemptions.
Well, they could. I have encountered instances where photographs, of crime scenes or that contain pictures of victims can constitute arguably medical information that's protected. So you have to look at each document specifically to see its content and make a judgment call on that. Obviously, not all crime scenes will fall into that category. Not all pictures of people will fall into that category, but they could. They could. So if you have a picture, for example, that's depicting victims, accident victims, or otherwise other types of victims, you could well be in the zone of having to invoke a medical information privilege. What was the other question, Janice? It was
pictures of or fatal accidents or injured or deceased.
Yeah, that was that's my take on that subject, is that it's possible the medical information exemption could come into play. It's also possible, again, it depends on what is the status of any law enforcement proceeding that might be related to the incident. I mean, Sarah's going to talk in a little bit about the investigative exemption, which will come up for the sheriff's office quite frequently, I would imagine. And some of these types of documents might come into play and be subject to that type of exemption, but we'll talk a little bit more about that shortly.
And also there's a general question about case reports and sort of there, of course, there are going to be lots of requests for case reports at any law enforcement agency, and sort of the correct way to treat requests for case reports.
There's no general rule. There's no general exemption for case reports in the statute. One of the principles that we're going to kind of try to drive home towards the end of this presentation is that you have to have an exemption under the law. It's either under the PIA or under some other source, some other legal authority for withholding a record. So there's no such exemption for case reports per se. There is a discretionary exemption for investigative records and files, and there could be information within a case report that might fall, depending on what the incident is, what its status is in your office, depending on whether you have an open and active investigation, depending on any number of factors that could bring information within a case report, make particular information exempt. But as a general rule, I would not expect case reports as a generic type of document to be exempt. I would think they would be disclosable.
All right, thank you. I think those are all the questions about the material we've already gone over. I'm going to save the 10-day roll question and the open investigation question for after we cover those matters. Sarah, you're up.
Okay, so I'm going to talk a little bit about one of the discretionary exemptions in Part 4 that would come up, I think, quite often for an agency like a sheriff's office. So Part 4 does provide the discretionary exemptions. What that means is that a custodian can withhold the record or the information within a record, but only if it's contrary to the public interest. So it doesn't mean discretionary in that, you sort of just decide whether or not you feel like withholding it. There has to be a judgment made, right? Whether or not releasing this information would be contrary to the public interest. And we'll talk a little bit more about that in a minute. So some of the exemptions that fall under this category are interagency or intra-agency memos. And that would include material that's protected by attorney work product privilege. So for instance, maybe emails that might be exchanged between Mr. Dixon and the PIA custodian in the sheriff's office. That would fall under attorney work or attorney client privilege, potentially work product privilege. And then also the deliberative process privilege, which really sort of protects decision making and sort of the free flow of communication around making decisions. 4-351, this is the one that really I think will probably come up most often for something like a sheriff's office or a state's attorney's office that would potentially exempt records of investigations and security procedures, and then emergency response plans, building plans, things of that nature if the disclosure would endanger public security, and that's 4-352. So under 4-351, I think, again, the main sort of takeaway here for the sheriff's office would be that records of investigations are potentially exempt. There are circumstances under which those records or information in those records could be withheld, again, only if it is contrary to the public interest. It is important to note that just simply sort of stating blanketly that it's contrary to public interest usually isn't going to be enough. There has to be sort of a reason or an explanation or an example of why disclosure would be contrary to the public interest. So section 1, I think, is really the one that's going to apply most to all of you. Also, just to note, an investigatory file compiled for any other law enforcement purpose. So there may be some agencies whose primary function isn't the enforcement of laws, but there may still be files that are investigatory in nature that are compiled for that purpose. Those may also be exempt. And then again, the exemption for the intelligence, information, or security procedures, again, of these law enforcement bodies. So some things to consider when deciding whether or not to withhold an investigative file would be, again, the purpose of it. And for the sheriff's office, it's sort of a per se law enforcement purpose. The records that you would hold, generally speaking, are presumed to be for a law enforcement purpose. The status of an investigation is important, whether it is an open, ongoing investigation or a closed investigation. I guess going back again to this idea of having to sort of explain why it's contrary, courts have said that when an investigation is open and ongoing, that alone is sufficient to sort of explain why disclosure might be contrary to the public interest, right? So while a criminal case is going on, there are rules of discovery that kind of govern the information that can be disclosed to a defendant and his or her attorney. And so, we wouldn't want to sort of jeopardize an investigation or a trial by just sort of disclosing beyond that. So in that kind of a situation, just the fact that the investigation is open may be enough to say, you know what, I'm not going to disclose this information at this point. And it's also important to keep in mind that even if, say, you have a closed file and generally disclosure would not be contrary to the public interest, there still may be information in that file that could be redacted, for instance. So information about confidential sources or information that might reveal the investigative techniques of the agency, that kind of information could be severed from the record and therefore allow disclosure of the record sort of generally. And then again, this is another exemption to where the idea of a person in interest has sort of a greater right of access. And again, a person in interest, particularly for you all, is often going to be the defendant in a criminal case, or his or her representative as counsel. And so the legislature has said that when it's a person in interest who is requesting his or her record, that there is this sort of heightened standard that you have to meet in order to, in order to deny those records. And so there are these 7 considerations. Interference with a valid and proper law enforcement proceeding. Again, this is sort of where, if a defendant were to request his or her file when the case is still open, the courts have said that's sort of almost a presumed interference with a valid and proper law enforcement proceeding. If it would deprive another person of their right to a fair trial, if it would constitute an unwarranted invasion of personal privacy, if it would disclose the identity of a confidential source or an investigative technique or procedure, if it would prejudice the investigation, and that's, it's a little, that sort of relates back again to the first factor, and if it would endanger the life or physical safety of an individual. And again, when you're considering a person in interest, and you say you find some information that you say might satisfy one of these criteria, again, you want to err on the side of disclosure. So if you can disclose that record by redacting, say, the address of an individual, or redacting the name of the confidential source, you should do it that way and disclose everything else that is disclosable. There's also a discussion. Oh, yes.
Sarah, can I interrupt you just a moment? I just want to go back to the open investigation. If it's an open case and you withhold the information saying that this is an open case, and then the case closes, or does the person have to then resubmit when the case is closed, or is there a best practice in sort of response to a PIA request when the investigation is open?
So I think it's going to sort of depend on the agency and how robust I think their tracking is. I mean, I think a person can submit a new request at any point. Some cases and some investigations are going to last a very long time. It may be proper when the agency is responding to say in their response, we're denying it under for this reason at this point. This is an open, ongoing investigation, and it would be contrary to the public interest to reveal this information. However, when the investigation closed, this material may become disclosable, and let the requester know that they can check back and make their request anew. If the agency is able to sort of keep a track of those kinds of requests, it may want to do that and then revisit the request once the case is closed. That the courts have kind of talked about how it's not really a denial of disclosure, it's a deferment of disclosure, which can be kind of a little bit confusing in terms of, I guess, what the obligation of the agency is at that point. But I think this also sort of goes back to Lisa's point at the beginning of just, clear communication with your requester and explaining exactly why your reasons for withholding something and how that, that might change going forward. Does that make sense?
It does to me. I'll let you know if I get follow-up questions. Thank you.
So then there's another discretionary exemption that may arise for particularly an agency like a sheriff's office or a police department that is relatively new. It has to do with the 911 communication records. So this is in cases where the record involves a victim of domestic violence, sexual abuse, or child abuse. And there are some considerations that basically, I think the goal of it was to get the input of the subject of that call in terms of determining whether release is contrary to public interest. So when you get a request for this, the statute provides that within 30 days of getting that request, you have to the best you can, you have to notify that victim, right, the domestic violence victim, and let them know that the request has been made and whether or not that person has any input about whether it should be released, right, whether it's contrary to the public interest to release that information. That person has 10 days to respond to that outreach from the agency and sort of provide their viewpoint about the release of that or objection to release of that record. But again, it is ultimately the custodian who has discretion, right? So it's not, a victim would not have veto power. It doesn't have absolute power to say, no, you can't release that, but they do have the ability to provide input about whether or not it gets released. A couple sort of just things to keep in mind. This exemption doesn't apply if the record was introduced in court, which sort of makes sense, right? Because it's already it's been made public, it's part of a public record. So if, for instance, you're getting a request from a defendant many years after the case is concluded for their record and it contains a 911 record, and you know that that was entered as evidence in court, then that, can be disclosed. There's also a provision of that section that says, it shall be disclosed to a person in interest. Again, it could be with redactions to protect the parts that may be contrary to the public interest. But again, the person in interest has sort of this greater right of access. And then I'll turn it back to Lisa to talk about the special court order, unless there are any further questions about what we just talked about.
There's a question that goes back to, and it may be good for Lisa, sort of asking for clarity about disclosure of photos.
Right, I see that in the chat. It's a question. The question is, if we have a request for accident photos of an individual showing their face and injuries, we can give them out, question mark. So what I was, first of all, you can always give them out if the person who is the person who's depicted with the injuries gives you consent. You can always do it with consent of the individual, and you can always give it out to the person who is the subject of the photo. But when, let's say, a newspaper reporter calls you up and wants those photos, what I was suggesting before is you need to look at the content of the photo. If it is depicting what would be pertinent medical information about the individual, you may be obligated to withhold it under Force 329. There are police departments, I've come across instances where police departments are withholding photographs of individuals that depict their injuries. So anytime you have a photograph like that, you should be thinking, I need to look at this as potentially containing medical information. This could be an instance where knowing who the requester is would be relevant, because if it is the person who is depicted in the photo, they can always get their own information. So I hope that clarifies it. I know it's not intuitive, but a number of police departments do construe these photographs as containing protected medical information of individuals. Next question, how would we contact that victim with that law that began October 1? If you are referring to, I'm not sure if this is a question referring to
for the 911, I think.
911?
Yeah. So, I mean, I'm just kind of perplexed as to how that would, how that request would come in, I guess, because handling the 911 recordings, the vast majority of the stuff I deal with is the state's attorney's office or the lawyers that are a party to the domestic, the divorce, or whatever's going on. So if if lawyer A requests, and say that's the defendant's attorney requests that information, now I've got to try to figure out how to get in contact with the victim, and how is that by phone? Is that in writing? Is that, if I have no information to get a hold of the victim, and then only the attorney has the information. I mean, because most of the time, private attorneys aren't very forthcoming and give me very, very little information to go on when they request stuff. A lot of times I'm calling them, having to get and pull information out of them to find what they're looking for because they write their stuff so vague. So I'm just curious what kind of process or what's the best course of action to take on something like that?
So I think that I'm just looking at the statute really quick here. So I think that in a lot of cases, the state's attorney's office should have that information. So you may want to contact the state's attorney's office to see. I mean, there are like crime victim notification requirements and things like that. And, I think, and again, if this is something that's being requested during the pendency of a criminal case, which I know that's not always going to be the case, right? There are sometimes 911 calls that don't.
I'm more specifically say that there was a domestic.
Mm-hmm.
The police department goes out there. There's no report. Nobody gets arrested. But now I'm getting the request from the private attorneys because they're in the middle of a divorce. And a lot of times because there is no police report and stuff, and they give me very vague information of, oh, this person called 911 on this date. I want the 911 recording. Okay, what time? What address? Where I'm actually having to contact the attorney, like, hey, you didn't give me enough information to go on.
Right.
So most likely I'm not even going to have especially if it's a defense attorney, I'm not going to have the victims. So should I just tell them to go get a subpoena? Because most of the time we don't require them to get a subpoena. They send me an email and I have to fill the request.
Do you have the ability to listen to the 911 call?
I do.
Because that information, I mean, at least the phone number and the caller should be. I know it's not always the victim that's calling.
Right.
That could be one.
It's the neighbors calling 911 and things like that.
One of I'll tell you, I have not run into this issue so far in my caseload, but one of the things you can do is put it into mediation, and I can help you work with the requester on this. So we may be able to come up with a way to contact the person, or we may not. And if we can't, you may not be able to disclose it. They may have to go get a subpoena.
Okay.
But if you feel uncomfortable at having direct conversations with a requester along these lines, you can always consider putting it in mediation. And
well, I guess my more of the concern is not so much with the requester, but the contacting the victim. Say I do have the phone number and I can call the victim. The days in caller ID, a lot of times I make phone calls out of here. I have to leave a message because they see something pop up on their phone. They don't know who it is. They're not answering the telephone, things like that because of all the, spam calls and things. But then is there a legal suggested, this is the appropriate wording of how we should go about this? Because I'm sure the reaction on the other end of the phone is probably not going to be palatable necessarily for them.
I mean, so the statute just says notify, and certainly, a phone message I think would constitute notification. The victim does not have to respond. I think you just let them know that you're calling, you got this request, you're calling because the law requires you to call, and that this person has 10 days to, respond and to let you know of any objections he or she might have, or concerns he or she might have about the release of the call.
Okay. Well,
and then if that 10 days passes and that person hasn't responded to you, and you're fairly confident that was the correct number, that was their voicemail, and that communication was received, I think then you can proceed from there.
Okay. Maybe there's, working with Tim, maybe there's some sort of standard language if we have to, when we do speak to these victims, that we should actually use that is like something that's already pre-scripted.
Yeah, I mean, that's
Sure.
definitely something.
That makes sense. Okay.
All right, Lisa, I don't think there are any more questions if you want to get to that last court order exemption.
Okay. So if you have a record that is not covered by any particular exemption or prohibition and other kinds of law, but you're very concerned about releasing it for some reason. For example, you are concerned that it may pose a risk to either an individual or to public safety for some reason, or you have some other grave concern about releasing the record or the information in it, but it doesn't seem to be covered by an exemption. You have an option to, now this is an option that will always require you to consult with and involve your legal counsel. But one of the things you can do is exercise the temporary denial mechanism, which allows you to temporarily deny a request or access to a record, but you have to go into court within 10 days of that denial and ask the court to rule upon the question of whether it is disclosable or not. If the court authorizes you to continue withholding inspection, then it is denied. On the other hand, if the court tells you you have to release it, then you will be releasing it pursuant to that court's ruling, presumably. So this brings me kind of to the kind of recap on exemptions. An exemption is something that you're going to look specifically to the act to find. Even if you're looking at section 4301, which is the section that adopts other sources of law as being potential sources of exemption. If you do not have an exemption, and if you do not have a court order that authorizes you to withhold the record, then you're disclosing it. So some things that are not exemptions. No, I'm not releasing this because it's against the public interest. No, not unless there's an exemption that allows you to withhold it, allows you or requires you to withhold it. I think this record is its release would constitute an unwarranted invasion of privacy. Nope. Only if you have an exemption that says so. Being an invasion of privacy is not kind of a generic standalone exemption that you can invoke as a basis to withhold a record. But we're a law enforcement agency. Nope, that's not an exemption. Being a law enforcement agency in and of itself is not an exemption. This is a kind of a summary of the exemptions landscape. You have some exemptions that are mandatory, in which you are actually prohibited from releasing the record. And then you have discretionary exemptions, those where you are authorized to withhold them, but you're not required to. And so these exemptions in many ways are the trickiest ones, because they're always going to require you to really carefully examine the content of the record, understand what its current status is, and whether there are reasons for withholding it that outweigh the general public interest in disclosure of records that underlies the PIA generally. If there's no exemption that applies, either directly under the PIA or by being imported into it under the other law category, if there's no exemption that applies, you're only withholding on a court order or under the temporary denial mechanism where you're going into court to get such an order. If only part of a record is exempt, then you are producing that record in redacted form. One of the points, I don't know if we've mentioned it, I don't think we specifically mentioned it, is if you are denying under a discretionary exemption, such as the investigative records exemption, and you determine that you can't release any part of the record, there's no part of the record that you can release, you are to be explaining why you can't produce it in redacted form. That was an amendment. That's a fairly recent amendment. Do we have any new questions concerning the subject matter so far?
I do not think so.
Okay. By the way, I should say, if you have questions that come to mind later, or if we have not fully answered your question, feel free to get in touch with us. We'll have our contact information up shortly. So we're always available to consult with you on particular questions. So let me turn now to the subject of timing. This is something I get a lot of people contacting me about with issues having to do with not having received responses on time or wondering what is happening with their request. So just before we get into this topic, it'd be interesting to see what your understanding is. Do you think there are time limits for responding to PIA requests? And if so, what are they? Do you have to respond promptly? Do you have to respond within 30 days? Can you respond within 60 days if you have permission from the requester? How about all of the above or none of the above? That's just kind of a quick pop quiz on the subject of timing. And the answer is all of the above. And the reason is the statute provides you should always be providing records as promptly as possible. In fact, if records are readily available, the statute speaks to providing them immediately. Of course, nothing happens immediately, ever, hardly ever, but you get the idea. The Act is trying to promote prompt production of records, not waiting until the 30th day. The general rule is to be providing records within 30 days, within 30 calendar days. If you need more time, the statute allows you to request an extension of up to 30 days from the requester. If you have the requester's consent, you can take up to 60 days to produce records. In this vein, I'll mention that if a matter is submitted to mediation through my office, which I'll talk a little bit more later about what I do, but if the parties agree to mediate, it tolls the time for responding to requests, meaning it stops the clock from running. While we're in mediation, the clock is not running. Okay, so this states the general timeframes under the Act are, many of them are provided by Section 4203. Promptly, but not more than 30 days after receiving the request for a record. If the response is if it's going to take you more than 10 working days, more than 10 business days to issue a final response and produce records, then you have to issue what is known as the 10-day letter. And that's 10 working days, not 10 calendar days. 4203B2 tells you what has to be in the 10-day letter. If it's going to take you more than 10 working days to respond to a request, you should be putting something in writing to the requester that tells the requester how much time you think is going to be needed to fulfill the request, the reason it's going to take more than 10 days, and if fees are part of the equation, meaning if you think, we'll talk about fees in a minute, but if you think you're going to be spending more than 2 hours in terms of having to locate the records, review the records, potentially redact the records, and therefore that you may be charging some fees, the 10-day letter is supposed to explain that and give an estimated range of fees that may be charged. It's just an estimate, you're not bound to it, but it should be kind of a good faith ballpark estimate of what type of fees, what magnitude of fees you think may be involved. What do you do if you get a request for a record but you don't have the record? And what do you do if you don't have the record but you have a pretty good idea of which agency or office does have the record? What you should be doing is notifying the requester, hopefully within 10 working days, that you don't have that record, but you think that the following agency or offices may well have it, and providing the contact information so that the requester can go to the correct agency or office and request it from them. So some of this is kind of common sense. It got worked into the statute because it wasn't happening enough. And so now we actually have statutory provisions that say this is what you should do if you don't have the record, but you know who does. Which takes us to the subject of denials. Denials are just what just what it sounds like when you tell somebody you have the record, but they can't have it, or they can't have a part of it for some reason. What do you have? What information do you have to provide about that? Well, you have to tell the requester why you are denying it. If it is being denied under a Part 4 exemption, those are the discretionary exemptions that we were talking about. For example, the investigative exemption is a discretionary exemption. The deliberative process privilege is a discretionary exemption. The intra-office memo is a discretionary exemption. Any discretionary exemption which comes under Part 4 of the statute, you have to explain why the record cannot be produced in a redacted form, if it can't. Of course, if it can be produced, if you determine it can be produced in a redacted form, then that is what you are going to be doing. Brief description of the record being withheld without disclosing protected information. The reason you are providing that information is what you want to be conveying to the requester is, what is it about this record that ties it to the exemption? So, for example, this is a legal memo that is part of an active case investigation. In which case, it's probably coming under multiple exemptions. It could be an investigatory exemption. It could be attorney-client privileged exemption. It could be attorney work product. But you're telling the person something about the nature of the document that links it to the specific exemption that you're citing. Legal authority for the denial. Usually this is going to be a section of the act that authorizes or requires you to withhold. This is a protected personnel record. Section 4311 of the act prohibits us from releasing this record. If you're in doubt about the legal authority for the denial, you'll want to be in touch with your counsel to help you out with that. Notice of remedies. If a requester is dissatisfied with the denial, they have a number of options and avenues they can pursue to obtain release, and so you are to give notice of that fact. What are the remedies available to a requester who is dissatisfied? Well, they can go to court. They can challenge your denial in court. That's called seeking judicial review. If the dispute is about a fee that you are assessing that is more than $350, they can file a complaint with the PIA Compliance Board. That board can review fees if they're more than $350 and determine if the fee comports with what is allowed under the Public Information Act. Or they can come to my office and I can try to mediate the issue. Everything, I'll talk a little bit more about what I do, but everything that I do is on a completely voluntary basis and on a confidential basis as well. Okay, so this would be a good time to talk about fees. I'm not sure how often the Sheriff's Department has occasion to charge fees, but in general, fees are governed by Section 4206 of the Act. The thing to know is that you can charge fees, but it's subject to a few limitations. For example, you have to give every requester up to 2 free hours of your labor. Labor can be, what it takes to locate the record, what it takes to review the record, what it takes to redact the record, to get it ready to produce. If the sum total of all these tasks is going to exceed 2 free hours, the 2 free hours required by law, then the clock can start running if you're going to be sending out a fee estimate and charging fees. Note, by the way, you never have to charge fees. Nothing ever makes you charge a fee. But if you want to charge a fee, you have to be mindful of some of these limitations. So one of those limitations are the 2 free hours of labor, which you're obliged to give to every requester. Sometimes, I see a lot of this in my caseload. When people get a fee assessment, they very frequently don't understand why it is. I'm a citizen. This is my government. I have a right to this information. Why am I being charged a fee for this? So this is not necessarily a legal issue, but from a public relations standpoint and from a customer service standpoint, you want to be mindful how the fee may, who your customer is and how this may be perceived. I'll tell you, I once had a matter where I kid you not, $1 million fee was charged. The letter that went out with the fee estimate estimated $1 million. Now, it was a huge request. I will grant you that. And the person who wrote this letter with the fee estimate was completely serious. They were very thorough in their analysis and their explanation about why the fee was going to be this large. But I will tell you, this member of the public who requested this information hit the roof. It was like, you're telling me I have to pay $1 million to get public records? You've got to be kidding me. So this is just kind of a caution to keep in mind how these things are going to be viewed by your constituent or by your customer. If there's disagreement, you can always come to my office for mediation. You can also suggest to the requester that they may want to involve my office. Some of the things I do in mediation is try to help reframe requests in such a way that we can get the fee and the burden down. We're still on section 4206. What is it you can charge for? I think first of all, your fee has to be reasonable. The fee must, and reasonable in this context means the fee must be connected to the agency's actual costs incurred in preparing and locating, preparing and producing the records. So you can't be charging fees kind of as operating it as kind of an independent profit center. It always has to be tied to recoupment of your actual costs. You can charge for search and review time. Labor charges would typically be the hourly rate of the employees involved minus, you would not include whatever is being paid for benefits for a person. It would be the hourly rate calculated on a pro rata basis and provided you give the first 2 hours free. If you have actual expense items, such as in the olden days, before we had all this electronic records available, it was very common for agencies to charge for photocopies on a per page basis. You can still do this, provided you know what your actual costs are, you can still do this. If you have other items of actual expense, sometimes agencies will go out and purchase a flash drive or something of that sort. You can recoup that actual expense. You can recoup that and include it in part of your fee estimate. Let me just, I see there's a new question. Let me just see if we can cover the rest of fees, and then we can double back and answer some more questions. So even if fees are estimated or projected in handling a particular request, a requester can ask for a fee waiver. 4206 has provisions that are specifically directed to the handling of requests for waiver. Both the assessment of fees and the decision to waive fees is discretionary with the agency, but the statute does direct that the agency should consider whether waiver of fees is in the public interest, and also if financial hardship in the form of indigence, we'll come down to we'll talk a little bit more about what that means, is asserted as a basis for the waiver request, you have to consider it. You have to give consideration to that specific basis for waiving fees. Now, indigence is kind of a term of art. Okay, well, first before we get to indigence, we're going to talk about public interest. The statute doesn't tell you what is in the public interest. It just says you have to consider it. Many agencies will invite the requester to explain why they believe the public interest would support waiver. One of the fairly well recognized bases is that the record or the information in it is going to be disseminated on a broader basis. So, for example, when members of the press or media or even bloggers are requesting information because they want to write about it, they want to report it, they want to make the information available to a larger group of people, that can be considered and weighed in the mix as to whether the request for waiver is in the public interest. In general, there's no litmus test on this, but one of the things I would suggest is perhaps a useful kind of framework to use is how closely is this request tied to the purposes of the Public Information Act. So as we recall, when we started off this our discussion this morning, we talked about the principles, the general principles involved, and that the purpose of the act is to shine a light on the activities of government for the benefit of our democracy, for the benefit of public participation in government, for the purpose of furthering public awareness of what their government is doing. So one of the questions you can ask, and you can invite the requester to explain to you, is how the request is tied in with those fundamental purposes. And to the extent the information is consistent with or advances those interests, you can consider all of those factors in weighing the request for waiver. Now, a distinct basis has to do with the ability of the applicant to pay the fee. And so if someone is seeking records, particularly, let's say, about themselves or some action that government has taken with reference to them, and they can't pay for them, you can consider that as a basis, as an independent basis for waiving the fee. So this brings me now to the subject of an indigent waiver. Only individuals can be indigent. Businesses are never indigent. Advocacy groups or organizations are never indigent. Only people are indigent. In order to be indigency, or being an indigent, is actually kind of a term of art, and it has a somewhat complicated definition. In general, it requires that the person's household income is less than 50% of the median family income for the state. So and so this number, the actual value, fluctuates over time. It changes over time as the median family income changes over time. So in 2014, 50% of the median income for a family of four was $52,500. It may be somewhat higher right now, but I don't think it is tremendously higher in the state of Maryland. So, and obviously it would be less for a single person. Typically indigents, you can ask a requester to document their financial status in the form of an affidavit, and so hence these are referred to as affidavits of indigence. The PIA manual, which is published by the Attorney General's office, has a sample affidavit of indigence in it. You can refer to that for your own information. You can also provide it to requesters. If they have not submitted their own affidavits, you can provide them with that form, ask them to complete it. In general, it just requires people to list out their income, their assets, information about their family size, household size, and the like, so that you can determine if they meet this definition or not. Okay, some good guidelines for handling issues about fees. Oftentimes this issue is going to come, when it comes up often because the request is very broad and taken literally calls for the agency, to be scouring thousands of emails or, a decade's worth of records. I mean, I'm exaggerating a little bit just to make a point. But sometimes these fee issues can be addressed by talking to the requester and explaining to them why it is going to be very time consuming and costly to literally fulfill their request. Once you've done that, you may be able to help the requester refocus or reframe their request in a way that calls for a more specific response, one that doesn't require you to go searching through banker's boxes worth of documents, or reviewing thousands of emails. Because you are the custodian of your own records, you may well be in the best position to make those suggestions to a requester. And if you don't feel comfortable having those conversations directly with the requester, you can always consider either putting it in mediation yourself or suggesting to the requester that they may want to involve my office. When I'm working on fee issues with requesters and agency, I'm doing a lot of the talking, explaining, and trying to come up with suggestions about alternate approaches. One of the things I'll frequently point out to requesters is, you don't have to ask for, the Earth, the Moon, the Sun, and all the stars all at once, because you can make more requests in the future. If you don't get what you're looking for in the first request, you can take the information you get and then use it to formulate another request if the need arises. So there's no need for you to try to get, the whole thing all in one fell swoop. The other thing I very frequently will say to people is, do you really want 30 banker's boxes sitting in your living room of stuff you've got to go plowing through? Do you really want that? Or would you rather, let's focus in on what you're really looking for, and let's see if the agency can come up with that specific record or records. So those are some of the approaches that you could try and that I'm frequently engaging with people. Which brings me back to the subject we were talking about, remedies and options that are available to people. My office is known as the Office of the Public Access Ombudsman. It was created in 2015 by the legislature under Section 41B04, and I'm set up to do voluntary mediations. Generally, even before COVID, I was doing most of my work through email and phone. When we're not having a pandemic, I do in-person mediations on a more selective basis, depending on what the parties want, depending upon what seems most useful. The Public Information Act Compliance Board, this is an entity that was also created by the legislature in 2015. Its operation is governed by Section 411A04. The Public Information Act Compliance Board, or PIACB for short, is another office that Sarah represents. She works very closely with them, and their job is to review complaints about fees that are over $350 and determine whether or not those fee assessments comply with the law. Unlike my office, the board actually decides things. I don't decide anything. I try to bring the parties together on and hopefully try to fashion an agreement they can both live with. But the board is actually empowered to issue binding decisions. And those decisions are published, and they are available on the board's website, which we'll get to in a moment. Decisions of the board, as well as original actions filed in court, are a third option for review. Actions can be brought by agencies, for example, under the temporary denial mechanism that we were discussing, where an agency goes into court and asks for a ruling as to whether something has to be released or may be withheld. And they can also be brought by a requester who's dissatisfied with a denial, and in which case they can file an action under Section 4362 and ask the court to review whether the costs and fees or any other aspect of the agency's decision is permissible and comports with the law. I think we've covered this already. I mediate PIA disputes. I can consider any type of dispute at all that comes up under the PIA, whether it has to do with exemptions or redactions or late responses, missing responses, only partial responses. Impartial responses are always nice, but the law doesn't actually require impartial response. I think that should be partial, Janice, for just FYI for future references. Incomplete responses, fees. Agencies sometimes will put matters in mediations if they have a requester who keeps making the same request over and over again, or something very close to that. It becomes unduly burdensome. It's interfering with agency business. The agency has the ability to put that sort of matter into mediation with me. And, as I think I've said many times, either requester or the agency can initiate mediation. My door is equally open to both camps. Here's how you get in touch with me. We have a dedicated mailbox for submitting requests for mediation, which you see on the screen here. Janice Clark, who is kind of masterminding this presentation, monitors that mailbox constantly. and works very closely with Sarah and myself in terms of incoming requests for help. Below that, you have, I'm sorry, the first line is giving you our website, piaombuds.maryland.gov. That's our website. You can make a request for mediation via the website, or you can make it via the dedicated mailbox, pia.ombuds@oag.state, etc. We are all working remotely right now, and except when we're doing presentations like this and we're all in our offices, but you can reach us by phone because we're able to monitor our phone messages remotely. So feel free to get in touch with us via our website, by email, or by phone. If you go to the Ombudsman website, this is what you're going to see on the home page. You can see there are quick links over here to request mediation. If you want to make a PIA request in my office, you can do it via our website. If you want to see what are the documents that are readily available and that I can produce to anyone on request, you can check that out. We also link to the actual statute. We link to the manual the PIA manual that's published by the Office of the Attorney General. It's kind of the Bible in Maryland for detailed but a very accessible information about the Act and what it requires, what it prohibits. If you want to access the PIA Compliance Board's website, you can link to that. We have a Twitter feed. We try to put out announcements about things that are of interest. And we have other resource material posted on our website. Sarah, I'm wondering, we've covered some of this already, but do you want to talk a little bit about the PIA Compliance Board?
Sure.
What you do with the board?
Sure. So as Lisa sort of explained earlier, their jurisdiction is very limited. It's just complaints of unreasonable fees over $350. The requester is the only party that can initiate a complaint, which sort of makes sense. An agency is unlikely to raise any sort of complaint about their fees. Generally what happens is the complaint comes in from the requester. The agency then has a certain amount of time to respond to that complaint. And there are ways that the requester can also submit further information based on the agency's response. Once the board has all of the submissions, it will make a decision. Sometimes the board will actually come together and in some of the more thorny cases, have a conference about the issue, but more often than not, the decisions are made just based on the submissions alone. I will say, I think oftentimes what you will see is, again, sort of as Lisa mentioned, these very broad requests, in response, an agency will say, well, we think it's going to cost $2,500 to satisfy this request. The agency oftentimes in its letter won't go into a lot of detail about what makes up that fee. They may say, it's going to involve searching and reviewing and redacting and copying, but it won't really break down what that fee comprises in that initial letter. The requester will often sort of balk at that and go to the board. And what we'll find is when the agency responds to the complaint, at that point, the agency will sort of break down, well, we have to search through, 10 years worth of paper records, or we don't keep this information in readily available form. So that's going to, require us to sort of go through these records and compile things. Then our attorney is going to have to review it because there could be information that's sensitive or that we aren't able to disclose. Then we would have to redact it, and sort of goes more piece by piece about what that fee comprises. And sometimes at that point, a requester will actually say, oh, well, I didn't realize, that this amount of work would be involved in responding. Let me narrow my request at that point. So that is just sort of a plug for maybe being a little bit more explicit at the outset if the fee is going to be very large, and explaining why that fee is going to be very large. Again, the board only considers whether the fee is reasonable, i.e. whether it's tied to the actual costs of the agency in responding to a PIA request. oftentimes when an agency is able to explain in a fair amount of detail what those fees are comprising, it is going to be something that's reasonable. I guess there are instances, there was one case where an agency was just sort of charging a flat fee of $42 per CD for relating to an investigative file. In that case, the board sort of found that that wasn't sufficiently tied to its actual cost. The agency wasn't sort of able to explain why each CD was going to cost $42. But again, that is sort of the benchmark, I guess, of those cases is tying it to the actual costs and being able to articulate those costs.
Okay, I think that's a good summary of the board's work. Before I go through the next set of slides, I just see we have a couple of questions up here. I'm kind of going in reverse order. Where do we get the exemptions that are not in the 2015 PIA manual? So these would be exemptions that may have been enacted after the last date of the PIA manual. First of all, there is going to be a new PIA manual coming out soon. I can't tell you exactly when, but I do mean in the very near future. And then in that, Sarah, do you happen to know if that's going to be this year?
I think it'll be before the end of the year.
Before the end of the year.
Mm-hmm.
Okay, so we're talking about like within a month or two, you're going to have a brand new PIA manual that will be completely updated. Beyond that, I will say that on my website, we publish news of pertaining to the PIA, such as when a bill passes that affects the PIA. So there are typically, if you monitor our website and also our Twitter feed, when a bill passes that alters the PIA, we usually will send out a link to it, so you can subscribe to those items. Beyond that, I think Westlaw probably has the updates. They should have many of the updates since 2015. So, and if that doesn't answer your question, and if you are in need of something specific or want to get it sooner than the next manual's coming out, or without a Westlaw search, just email us what you're looking for, and we'll try to get that to you. So I hope that is helpful. Then backing up to the next preceding question, we actually have a series, looks like a series of questions. When does the 10-day rule to release a report take effect? Generally, it takes effect within 10 business days of the time the request is received. If the requester is out of state or county and we have to call them to give them the cost for the report, then wait for the payment, does the 10-day rule go into effect when payment is received or when the request that did not include a payment is received? Okay, let me try to take that apart. This 10-day rule generally applies to the time when you must, if you're going to do anything other than immediately produce the record without more, meaning no exemptions, no fees, here's the record, here's what you asked for, and here it is. If you're not going to do that, you should be sending out a 10-day letter. Even if you are ultimately planning to just produce everything without fees, but you're not going to be able to get to it within 10 business days, you should be sending out that 10-day letter. And you measure that 10-day time from the time you get the request. If part of the reason you're not going to get to this request within 10 days is because you're contemplating there are likely to be some fees, and you have to give them a fee estimate, you should be aiming to give them that information within 10 business days. We estimate that this will take at least 40 hours to complete all of the tasks necessary to fulfill your request. These include locating the records, reviewing the records to determine that they are responsive, and determining whether they're subject to exemptions. If they're subject to exemptions, we may have to consider whether it will be necessary. In other words, you explain why it's going to take more than 10 days. You give them a fee estimate, and you communicate with them about whether they're willing and able to pay that fee and to make arrangements for it. If you have that communication within 10 days, meaning you send out your letter explaining why it's going to take more than 10 days and what the fees are going to be within 10 days, you have satisfied that 10-day requirement. You're allowed to require prepayment of fees, meaning if somebody says, okay, I'm willing to pay your fee and I'm going to put the check in the mail, you are entitled to hold up production or even work on production until you get until you receive the payment. Now, if you're in communication with a requester about these things, I would suggest it's just good customer relations to discuss with them how you're going to manage this process. So some agencies will take a commitment to pay a fee as sufficient. And they'll get to work, once they have that commitment, they'll get to work on it. But as long as you have that initial communication within 10 days, you have met the requirement for the 10-day letter. So I hope that answers your question. If there are permutations on how these deadlines apply that I haven't addressed, feel free to call us or to email us, and Janice will help set up a time when we can talk in a little more depth about how this applies to the matter that you're concerned about. So, but in general, this 10-day rule is simply a rule that you have to have some initial communication with the requester, letting them know what has to happen before you can proceed with the request or before you can fulfill the request. And it's simply saying you must have that initial communication within 10 business days of getting the request. That's what that 10-day rule is all about. Okay, so the next series of slides is outlines a possible process for handling PIA requests. It was this is what do you call it? It could be viewed as like a workflow chart or as a decision tree. It was actually developed by the trainers at the State Department of Health. So they use it when they train their staff as to what they're supposed to be doing with PIA requests. And I thought it was a very useful kind of graphic on how this process can be proceeded. It outlines 5 steps. The first is, you know, a request is received and read, and certain basic determinations are made up front. I will commend this to your reading, and there's no requirement in the law that you do it this way. It's just a process that one agency has found to be useful. Step number 2, if you don't understand the request, or if you have some questions about what they're seeking, clarify the request. Clarify it directly with the requester. If you don't feel comfortable having that conversation with the requester, you can always consider involving my office. Third step, retrieving the records that are involved. Next step, reviewing the records. Once you've retrieved them, you review them. And then the 5th and final response is responding to the requester with various possible responses being indicated on the slide. Sixth, the 6th and last stage of this would be remedies if they're applicable. And we've mentioned this several times. Remedies include coming to my office for mediation, the filing of a complaint with the compliance board over a fee dispute, or going to court to review the agency's decision. These are some resources that are available to you, available online via the Attorney General's office. You can website, which is indicated at the top. You can also get them from the PIA manual is also available on my website, which we already saw a page from. This is the 2015 version of the PIA manual is the current version. It's about to be replaced by the 2020 PIA manual coming soon. The PIA manual has within it a section that is directed to agency custodians, and it has a suggested process for handling requests in a narrative form. It also has a section that's geared to the public consumer and outlines the Public Information Act process from the point of view of a requester. That is what the home page of the Attorney General's website looks like. To access the manual and other information, you want to go to the Services tab at the top, scroll down till you hit Open Government. You click on the Open Government tab, and you get a page that looks like this. If you have a Public Information Act question, you're dealing with the second bullet on this page. If it's a question about the Open Meetings Act, which is a completely separate statute, but it's another one of Maryland's open government laws, you would click on that. And do we have any other questions at this point that we haven't covered or that anybody wants to talk about more? You know, like I said, if you think of something after we disconnect this presentation or want to talk more about anything we've covered, just feel free to, you can email us or call us, and Sarah and Janice and I will be happy to work with you on whatever your question is.
Hi, this is Janice again. I want to again thank you all for showing up. We are amazingly right on time. I did provide to Sergeant Demira an evaluation form. If you would like, if you didn't get it, I'd be glad to send it to you also. I got a few people who emailed me and asked for a copy of the recording and the PowerPoint presentation, and I will follow up and send those to you. If anyone else would like that information, feel free to type your email address in the chat. You're welcome. Training guest number 1. And not seeing any other questions, I think have a nice day. Thank you so much.
Thank you. Thank you for joining us.